The next part of the rules that we're going to discuss are conflicts of interest. Conflicts of interest make up 12 to 18% of your MPRE exam. This is really important to understand that this is the most highly tested area of the rules. So if you are, say, preparing for the MPRE at the last minute, this is the place you should start, and you should focus your memorization here. Because again, this is the most highly tested area of the rules, and this by itself is going to make up 12 to 18% of your total MPRE exam. So here we're going to cover a few more rules than we normally do in the other subsections. So first and foremost, we're going to start with our current client conflict rule. So our general rule says that a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists in two scenarios. The first scenario in which this exists is when the representation of one client is going to be directly adverse to another. So turning to an example, let's say a lawyer is asked to represent the seller of a business in negotiations with a buyer that's represented by the lawyer, not in the same transaction, but in a completely separate transaction. The lawyer could not undertake that representation without the informed consent of each client. Why? Because even though this attorney is representing the buyer in an unrelated matter, this attorney owes a duty of loyalty to that buyer and therefore cannot be acting against that client in a different transaction. The second way in which we see these current client conflicts is if there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or even by personal interests of the lawyer himself. So turning to an example here. Let's say a lawyer is asked to represent several individuals seeking to form a joint venture. This lawyer is likely materially limited in his ability to recommend or advocate for all possible positions that might take place because of the lawyer's duty of loyalty to all of the others involved in this joint venture. Therefore, this conflict, in effect, forecloses alternatives that would otherwise be available to the client. So in other words, if I'm representing A, B, and C, they've hired me to, say, help them open up a business. My duty of loyalty runs to all of them equally. I cannot, say, advise individually just A about whether or not this business transaction is in his or her best interest, because I owe a duty of loyalty to A, B, and C jointly in regards to their business venture. So what happens if you do have this current or concurrent conflict of interest between your clients? The rule says that even if there is a current conflict of interest, a lawyer may represent a client if the following four requirements are met. First, the lawyer has to reasonably believe that the lawyer will be able to provide competent and diligent representation to each of the affected clients. In other words, if the lawyer knows that he or she cannot do her job properly under the circumstances, then the lawyer cannot move forward in representing both clients. So that's the first requirement. The second requirement is that the representation cannot be prohibited by law. I often get a lot of questions here. When we say that this representation cannot be prohibited by law, it's usually referring to the fact that there are certain jurisdictions that have passed laws that state attorneys cannot represent two criminal defendants in a capital case. That would be prohibited by law. So even if the attorney believes that he or she could represent both of the affected clients well, that attorney cannot move forward with that type of representation because it's prohibited by law. Or I know that a few jurisdictions have laws in place that say attorneys cannot represent both a husband and wife in a divorce proceeding. So that would be another example of where a current conflict of interest would be prohibited by law. Your third requirement to move forward here is that the representation does not involve the assertion of a claim by one client against another client, represented by the lawyer in the same litigation or other proceeding before a tribunal. So this means that you cannot represent both plaintiff and the defendant in the same action. That's just kind of weird and confusing. That's not a consentable conflict of interest. And our fourth requirement here to move forward is that each affected client gives their informed consent confirmed in writing, meaning oral consent does not count. So here, you want to make sure, and I should say for all conflict of interest rules, that you are making sure to pay attention as to who must be consenting to the conflict of interest. And also pay attention to these rules to determine how this consent must be recorded. It's very oftentimes the case where the client that is consenting to the conflict consents in a signed writing. But again, just to be sure that you are as prepared as possible for these MPRE questions, that is a portion of the rules that I would pay very close attention to when you study. So here, in order for this attorney to move forward with a current conflict of interest, the attorney would have to get this informed consent in a signed writing by both or all affected clients. The next rule that I want to talk about is our former client conflicts. So the rule says that a lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives their informed consent confirmed in writing. So just as I mentioned before, pay attention to who must consent and how. Here it's that former client in a signed writing. So, an example. A lawyer could not properly seek to rescind on behalf of a new client a contract that was drafted on behalf of an older client. So for instance, if someone hired me to draft all of their lease agreements because they owned commercial properties, and then later one of their tenants came to me to try to get out of that lease agreement, I could not do that without first obtaining that informed consent from my former client in a signed writing. When analyzing these conflicts of interest, you have to understand the definition of what substantially related means. Why? Because the plain language of the rule specifically says that a lawyer who has formally represented a client in a matter shall not thereafter represent another in the same or substantially related matter. So what does substantially related mean? This means that there's a substantial risk that confidential factual information, as would normally have been obtained in the prior representation, would materially advance the client's position in the subsequent matter. So turning to an example here. Let's say I represented a man in a business transaction, and throughout my representation of him, I learned a lot about the financial information about him personally and his business. I concluded that matter successfully. Later, his wife comes to me and asks me to represent her in a divorce from her husband, my former client. Well, that is not the same matter, right? I first represented him in a business transaction, and she has come to me seeking a divorce. So that is not the same matter. However, they are substantially related. Why? Because I obtained a whole bunch of confidential information about him and his business that is very important to this divorce proceeding. Therefore, I have a former client conflict, and the only way I could move forward to represent the wife would be to get consent from the husband in that signed writing. Moving on to the rule regarding clients of a lawyer's former firm. So here the rule says, a lawyer shall not knowingly represent a person in the same or substantially related matter in which a firm with which that lawyer was formally associated had previously represented a client, whose interests are materially adverse to that person, and about whom the lawyer has acquired information protected by our duty of confidentiality that's material to the matter unless that former client gives their informed consent confirmed in writing. So let's stop there. This basically means that if you are working for law firm A, and obviously because you worked there, you have confidential information about law firm A's clients. If you switch over and start working at law firm B, you cannot use all of that information you gained about law firm A's clients to the benefit of law firm B's clients, right? Think about the type of world we would live in if this rule didn't exist. Clients would be very weary and afraid to share any information with attorneys because that attorney could simply leave the firm and use all of that information to the benefit of, say, the opposing party of that previous client. So that is not permissible. That attorney would have to get the informed consent in writing from that previous client of their former firm to move forward. It's also helpful to know that any lawyer who has general access to all of the files at a law firm and who participate regularly in discussions of client affairs are inferred to have information about all of the clients of the firm. In other words, if you can access the information and you participate in discussions about clients, then this rule applies to you. And we just assume that you have confidential information about those clients. Additionally, moving on to the next portion of the rule, it says a lawyer who has formally represented a client in a matter, or whose present or former firm has formally represented a client in a matter, shall not thereafter use information relating to this representation to the disadvantage of this former client, except as the rules would otherwise permit or require with respect to the client, or when the information has become generally known, or reveal this information relating to the representation except as the rules would permit. And again, this makes sense because if someone has trusted you with information and maybe you've worked on their case or your law firm has worked on their case, it does not seem right that you could later use that information or disclose it or reveal it without their permission. It's also helpful to understand here that we're talking about former client conflicts generally. And nowadays, most attorneys do not stay at one law firm forever. We know that people change jobs. So this can create major issues. It's helpful to know why. And this is because your conflict of interest as an attorney is imputed onto your whole law firm, generally speaking. There are some minor exceptions, which I'll talk about, but generally your conflict of interest is your law firm's conflict of interest. And this can obviously be troubling. Say if you worked at law firm A and you came over to law firm B, all of your conflicts of interest come with you and become law firm B's problems. So how do law firms still take on clients and generate business with all of their attorneys having their own conflict of interests that preclude the whole firm from working on matters? And the way around this is screening. This means that if you worked at law firm A and you quit and started working at law firm B, and if there was a conflict of interest due to, say, your change of employment, you could still be hired by law firm B and you can still work at law firm B, but you would simply be screened off of that case. And that would allow law firm B to move forward with that client. You just would have nothing to do with it. Moving on to the rule regarding prospective client conflicts. So here we start by defining who is a prospective client. And this is a person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter. These people are all considered prospective clients. The rule here says that even when no lawyer-client relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information unless an exception to confidentiality applies. And think about this again, the rationale. If someone comes to you and explains some of the basics of their case, even though they don't hire you, they surely do not want you to reveal that information or use that information against them. So you can't. You have to maintain that that information is confidential and you can only disclose it if an exception applies. The next portion of the rule says, a lawyer shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter if the lawyer received information from the prospective client that would be significantly harmful to the person in the matter, except as provided below. So this means if you take a meeting with prospective client A and you learn information about them, but they do not hire you, you cannot go on and work for the opposing party in that matter. You're precluded from doing so, even though you were never actually hired by prospective client A. So how do we get around this rule? Because this too is imputed on your other firm members, meaning your whole firm is not allowed to handle that matter in any way. So how do we get around it? The first way around this is to get informed consent from both affected clients. This has to be confirmed in writing. So this means if prospective client A comes to you but doesn't hire you, but then prospective client B comes to you, who happens to be A's opposing party, and B wants to hire you, the only way you can move forward with that representation is to get informed consent from both parties in a signed writing. Or the second way around this conflict of interest is screening. This means the lawyer that took that meeting with that prospective client limited the information that they took in, which means, they made sure that they didn't learn every single detail about the case, but they just learned as whatever facts were necessary for that basic meeting, and then they're screened off of that matter. They do not make any money off of it, and they do not participate in it in any way, shape, or form. And then notice of this screening procedure would be given to that prospective client that's affected. As I've already stated before, imputed conflicts here mean that your conflict of interest becomes your law firm's conflict of interest. Just like your colleagues at work, their conflicts of interest are also your law firm's problems. In other words, law firms and all of the people within a law firm are treated like one person for the purposes of these conflict of interest rules. Meaning if your colleague cannot take on a case because of a conflict of interest, you too cannot take on the case. The exceptions to that rule, meaning there are some types of conflicts of interest that are not imputed onto other firm members. And this is when the prohibition is based on some sort of personal interest. It's usually some sort of political feeling or some sort of religious reason that they are, say, conflicted out from handling a case. Those types of conflicts of interest are not imputed onto the rest of the firm. So again, if someone has very closely held religious beliefs or political beliefs that do not permit them to take on a certain case, those are personal to them and not imputed on the rest of the firm. However, all of the other conflicts of interest are imputed, generally speaking. The next rule that I want to talk about here is moving on to business transactions with our clients. And the first thing I like to say here is not everyone remembers that entering into a business transaction with your client is actually a conflict of interest, but it is. Remember, we're supposed to be our client's agent and their fiduciary. So if we enter into a business transaction with them, the lines here become a little muddled. Whose interests do you really have here? Are you more concerned about yourself or your client's best interests? So that's why entering into a business transaction with your client is technically a conflict of interest. So this rule says a lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest that's adverse to a client, unless the transaction and its terms on which the lawyer acquires this interest are fair and reasonable to the client and fully disclosed and transmitted in writing in a manner that the client can reasonably understand. The client is advised in writing of the desirability of seeking and given a reasonable opportunity to actually seek the advice of independent legal counsel on the matter. And then finally, the client gives their informed consent in a signed writing as to the essential terms of this transaction and the lawyer's role in this transaction, including whether or not the lawyer is representing the client in the transaction. It's also helpful to know here that if your client is already represented by independent counsel, you do not have to advise them to go get different counsel because hopefully, if they're already independently represented by someone, that attorney has their best interests in mind in regards to this transaction. Additionally, this rule does not apply to ordinary commercial transactions. So the example I almost always give is Starbucks. I love Starbucks. Let's say that I was Starbucks in-house counsel or I worked for them. I am still allowed to go to my local Starbucks location and order my coffee on my way to work every day. That's considered an ordinary commercial transaction, and it does not fall within the definition of the business transaction that we are basically afraid of for the purposes of conflict of interest rules. The next rule that I want to talk about says a lawyer shall not solicit any substantial gift from a client, including a testamentary gift, or prepare on behalf of a client an instrument, giving the lawyer or a person related to the lawyer any substantial gift unless the lawyer or other recipient of the gift is related to the client. Related persons here include spouses, children, grandchildren, parents, grandparents, or any other relative or individual with whom that lawyer or the client maintains a close family-like relationship with. So let's just stop there for a second. Let's break down this rule. This means that you as an attorney can accept gifts from your client, even substantial gifts, but you cannot solicit gifts from your client, and there's a difference there. However, be wary when it comes to accepting a gift from a client, because if, say, they get mad at you and they want that gift back, they could probably claim some sort of undue influence upon that transaction and get the subject of that gift back. The next thing I want to point out about this rule is that it's basically, it is saying that you shall not prepare, say, a will or a trust on behalf of your client if they are going to be leaving you or any of your family members a gift. Because again, this brings about a situation where it tends to look like undue influence. Maybe you forced your client's hand at making this gift to yourself or your child or your family member. And we obviously do not like putting people in that situation. However, you can draft wills or trusts or any other testamentary instrument on behalf of your family members, and those people can leave you gifts, and they can leave your children and other family members gifts. The rationale behind this rule is that they would probably leave you a gift even if you were not the one drafting their testamentary instrument. And better yet, if they died without a will, for instance, if you are related to them, you would probably inherit from them anyways under the laws of intestacy. So really the dangers of this type of transaction are not applicable to family-like situations. The next conflict of interest rule that I want to cover says that prior to the conclusion of representation of a client, a lawyer shall not make or negotiate an agreement, giving the lawyer literary or media rights to a portrayal or account based on substantial part of information relating to the representation. So the whole takeaway here is if your client is, say, famous, and they're, say, running out of money to pay you for your legal services, you cannot negotiate a deal where you take, say, media rights to some sort of book or movie portrayal of their legal issues. You cannot do this while the matter is ongoing, and you cannot negotiate it. And that is the big takeaway from this rule. The next conflict of interest rule that is worth going over says that a lawyer shall not provide financial assistance to a client in connection with pending or contemplated litigation, except that a lawyer may advance court costs and the expenses of litigation, the repayment of which may be contingent upon the outcome of the matter. And to be honest, most law firms operate this way. They do front a lot of the expenses of litigation on behalf of their client, and they simply get paid back later. And that's just to make litigation run more smoothly, because it would be kind of a pain if every single time they needed a check from their client, they would have to wait on their client to cut that check, say to draft a motion or to file a motion or something like that. So again, this rule is saying you're not supposed to provide financial assistance unless you're, say, advancing court fees or litigation expenses. The next part of the rule says that if you're representing an indigent client, you may pay court costs and expenses of litigation on behalf of your client. And this is just the idea that, let's say you're doing some pro bono work, so you're already working for free, and if you feel that you want to pay the court costs out of your own pocket, you can do that if your client is in fact indigent. The next rule that I want to talk about is in regards to malpractice liability. Here the rule says a lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making this agreement. I'm going to stop right there. This is a very unique rule. This is the only rule throughout all of these rules that you need to know for this exam that requires your client to be independently represented by another attorney in making this agreement. All of these other rules that you review or that we've talked about encourage your client to seek outside counsel on the matter, but do not actually require your client to have outside counsel. This is the only rule that requires your client to have another attorney involved to be able to enter into this type of agreement. And if you think about it, it's a really kind of important rule in agreement, because we would have lawyers simply asking all of their prospective clients to waive malpractice. And that just doesn't seem right. So if you are going to ask your client to waive any sort of prospective malpractice claim, the only way you can actually effectuate that agreement is if they were represented by an attorney in entering into that agreement. But that is the only way. When it comes to settling a claim, however, let's turn to this rule. So it says a lawyer shall not settle a claim or potential claim for malpractice liability with an unrepresented client or a former client unless that person is advised in writing of the desirability of seeking and is given a reasonable opportunity to actually seek the advice of independent legal counsel in connection with this matter. So again, just to compare the rules, if you're asking someone to prospectively waive malpractice, they have to have an independent attorney in entering into that agreement. But if you're asking an unrepresented person to settle a malpractice claim, or a former client, if you're trying to settle a malpractice claim, you have to advise them that they should probably get their own attorney, and you're going to give them time to get that attorney. But they do not have to ultimately be represented independently to settle that claim. The next rule that I want to discuss, there's actually two, and these are the conflict of interest rules that surround themselves regarding attorneys who say go from working at a government agency or say a prosecutor's office and they transition into the private sector, or someone who goes from say a private law firm and transitions to working for the government in some capacity. So this first rule we're talking about is going from government work to private work. So here the rule says, except as the law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government is subject to the former client conflict rules, which we've already covered, and they may not otherwise represent a client in connection with a matter in which the lawyer participated personally and substantially as a public officer or employee, unless the appropriate government agency gives its informed consent confirmed in writing to the representation. So let's just stop there. So this basically means that you're turning to your former client, so to speak, that government agency, and you're getting their consent in writing to move forward with this conflict of interest. It's much like the other rules we've seen where you turn to your former client and get their consent. There's some words here that you have to understand the definitions of to be able to work through some of these questions presented. First and foremost, you have to understand the definition of matter, because the word matter is used in this rule. So matter means, is defined, I should say, quite narrowly, and it means a specific set of facts involving specific parties. So turning to our example here, it says a lawyer who worked on regulations for an agency when she worked for the government, then was asked when she moved into the private sector to argue that the regulations were not applied properly to a specific party. The lawyer may represent this party. Why? Because drafting regulations is not considered a matter since it does not involve specific facts or specific parties. The other words you need to know the definitions of are personally and substantially, as these are also used in this rule. So this means that the lawyer was personally involved. So they kind of are as they sound. Turning to an example here, it says, let's say a lawyer was the senior attorney in a county, and she rubber stamped her signature on every single case that came through that county. The lawyer is not considered to be personally and substantially involved in every case. She would only be involved in the ones that she truly participated in. It's also good to know that any sort of conflict of interest that arises under this rule is also deemed to be imputed on the rest of your firm as well. Much like we've already been discussing, conflicts of interest tend to be imputed upon your other firm members, with those very kind of limited exceptions regarding your personal conflicts of interest. Let's turn to the reverse. So now we're talking about an attorney who goes from the private sector to, say, working for a government agency, and the conflict of interest rules that come into play here. So the rule says, except as the law may otherwise expressly permit, a lawyer currently serving as a public officer or employee is subject to the present client conflict rules as well as the former client conflict rules. Additionally, they may not participate in a matter in which they participated personally and substantially while in private practice or non-governmental employment, unless the appropriate government agency gives its informed consent confirmed in writing. So let's talk about an example here. Let's say a lawyer did zoning ordinance work in private practice for a company where he would challenge local zoning ordinances. Lawyer then leaves this private practice to work in the public sector for the government, where he then rewrites the zoning ordinances that he used to challenge. While working for the government, the lawyer would need to receive the informed consent in writing from that governmental agency in which he was working for due to the nature of his previous work in the private sector. Moving on, the next part of this rule says that lawyers here may not negotiate for private employment with any person who is involved as a party or as a lawyer for a party in a matter in which they are participating personally and substantially. So let's say you are working as a prosecutor. You cannot be negotiating for employment with defense counsel's firm while you are handling a case, because again, it tends to kind of muddle where your duty of loyalty is. Is it to actually prosecuting the case, or is it to yourself in trying to land this job with defense counsel's firm? The one exception here is if a lawyer is serving as a law clerk, to say a judge. These people can negotiate for private employment as permitted by the rules, which we'll talk about here in just a second. And then the last rule that we're going to discuss under the conflicts of interest is all about former judges, arbitrators, mediators, or third-party neutrals. So starting with our general rule, it says a lawyer shall not represent anyone in connection with a matter in which the lawyer participated personally and substantially as a judge or other adjudicative officer or law clerk to such a person, or as an arbitrator, mediator, or third-party neutral, unless all parties to this proceeding give their informed consent confirmed in writing. So again, if you're working as a neutral, maybe you're an arbitrator, maybe you're a judge, you cannot move forward and say represent the plaintiff or the defendant in a matter in which you presided over. The only way you could do that is if you received the informed consent confirmed in writing from all of the parties involved. The one exception to this rule here is if you are a partisan arbitrator. So if you are an arbitrator selected by a party in a multi-member arbitration panel, then you are not prohibited from subsequently representing that party. So this is usually the case where there are 3 arbitrators on a panel. Normally plaintiff picks plaintiff's arbitrator, defendant picks defendant's arbitrator, and then the 2 arbitrators together agree on that 3rd arbitrator. Well, if you are a plaintiff's arbitrator, after arbitration ends, you can go on and represent plaintiff, because we all know that you were plaintiff's arbitrator. So that is the exception here. It's also good to understand that if you have a judge question and it tells you that a judge had exercised administrative responsibility in a court, this type of responsibility is not going to prevent that former judge from acting as a lawyer in a matter where that judge had previously exercised this very remote or incidental administrative responsibility that did not affect the merits. So for example, let's say under emergency circumstances, a judge was asked to hear a scheduling motion. And the normal judge who's assigned to the case was ill. Let's say he or she was in a hospital, obviously rather unexpectedly. So you heard this scheduling motion. This rule is saying that since that is very incidental and has nothing to do with the merits of the case, you could later move on to represent the plaintiff or the defendant in that matter if asked. And that's because you were not acting as a judge in the matter, but again, just exercising that very remote administrative responsibility. Here, the rule wants us to know that if you have some sort of conflict of interest that arises under this rule, it's also imputed onto the rest of your firm. So again, you're seeing a little bit of a trend here. All of these conflict of interest rules are imputed to your other firm members. And then I want to talk about the one exception where law clerks can negotiate for employment. So the general rule is a lawyer shall not negotiate for employment with any person who's involved as a party or as a lawyer for a party in a matter in which the lawyer is participating personally and substantially as a judge or other adjudicative officer, or as that arbitrator, mediator, or third-party neutral. Turning to our exception about law clerks. So a lawyer who's serving as a law clerk to a judge can negotiate for employment with a party or a lawyer involved in a matter in which they are participating personally and substantially, but only after that lawyer has notified the judge of the circumstances. If you want to know the rationale behind this rule, it might help you memorize it. It's just because being a law clerk is very temporary in nature. We all understand that this is not a long-term position for the most part. So if you are serving as a law clerk and you want to negotiate employment, you can do so long as the judge in which you're working for understands who it's with and the circumstances, and that judge can be involved. The whole takeaway from this is you should be transparent so that we make sure that everyone has their, fair day in court, so to speak, so that it does not appear that you as the law clerk are acting in any way that is unethical. So that wraps up our conflict of interest rules. And just to reiterate, these are the most highly tested areas of the rules, so be sure that you treat it accordingly.